So, hello everyone. Now, welcome to our second part. Now, earlier, as we have discussed the four requirements for the government contract. Okay, the last requirement I told that I will explain the case law for that. Now, firstly, we will discuss the case law of last requirement, then, we will proceed by quasi contractual liability. Okay, the last requirement was just recall it fast. Once again, I will just give a brief idea about it. The last requirement was that the contract which is entered should be in the name of president and the governor. Okay, otherwise it will be not valid and not binding a contract. Now, this is the case law which is above given here. DG Factory versus the state of राजस्थान. अभी केस लॉ बहुत ज़रूरी है लिखना क्योंकि हमें अगर से मार्क्स स्कोर करना है तो केस लॉ पे एक्चुअली ही कैन गिव impressively 1 mark. Okay, in any of the topic the case law should be written very precisely. Okay, in spite of fact and judgment, just write a heading and leave it. Okay, if you know the judgment for it and the fact, then you can write more about it. Okay, now in this case law what speaks about is that a contract was entered into by a contractor and the government. Now in this says contract बनाया गया था किसके बीच में, कॉन्ट्रैक्टर और गवर्नमेंट के बीच में. द एग्रीमेंट वॉज साइन बाय इंस्पेक्टर जनरल ऑफ पुलिस. और ये एग्रीमेंट किसने साइन करा था, इंस्पेक्टर जनरल ऑफ पुलिस ने. In his official status without stating that the agreement was executed on the behalf of governor. He did not state that, okay, that he executed on the behalf of governor. Okay, in the suit for the damages filed for the contractor for breach of the contract. Breach means what? Breach is a legal word. Breach means तोड़ना कोई contract को. क्या करना? तोड़ना. Breach of a contract. The Supreme Court held that the provisions of Article 299 subclause 1 were not complied with and the contract was not enforceable. Sorry. अभी इसके अंदर on the behalf of president नहीं है and he did not state it also, so this is not compiled to Article 299. तो अगर से वो 299 1 सब क्लास 1 की कंडीशन को फॉलो ही नहीं करेगा जो कि ऑन द बिहाफ ऑफ प्रेसिडेंट है, तो ये एनफोर्सेबल होगा ही नहीं. तो दिस विल बी नॉट अ वैलिड कॉन्ट्रैक्ट. ओके, now this is all about the case law. Now our next topic we will learn is that quasi contractual liability, जो क्या बताता, doctrine of unjust enrichment. Now in briefly orally I will explain you this topic and you can just read on this notes precisely. अभी डॉक्ट्रिन ऑफ अनजस्ट एनरिचमेंट क्या होता है, अगर से एक व्यक्ति को गलती से दूसरे के गुड्स आ गए उसके पास में. सपोज डिलीवरी मैन, यू हैव जस्ट पुट डिलीवरी ऑन द फ्लिपकार्ट फॉर एनी ऑफ द कॉस्मेटिक प्रोडक्ट्स. सो ही डिलीवर टू mistakenly to another person and that another person has detained it and use it. Okay, so he has right to compensate from him. He have to reimburse that money. Okay, अगर से एक व्यक्ति ने दूसरे के गुड्स बाय मिस्टेकनली यूज़ कर लिए है तो उसको कंपनसेशन देना होगा, भले गलती से, बट उसके राइट्स का इन्फ्रिजमेंट नहीं होगा, उसको कंपनसेशन देना ज़रूरी है. इट फोक एंड सेक्शन 17 ऑफ इंडियन कॉन्ट्रैक्ट एक्ट, कौन सा, सेक्शन 17 ऑफ इंडियन कॉन्ट्रैक्ट एक्ट 1872 ही बताता है ये, क्या हम अनजस्ट एनरिचमेंट नहीं होने देंगे और कंपनसेशन विल बी गिवन. ओके, नाउ दिस इज़ ऑल अबाउट द quasi contractual liability. Now we ends this topic. The next video is all about the government contract and the role of judiciary. Okay, stay tuned guys.